Hello, this is Henry Quillian. I'm here at Taylor English Duma with my colleagues for Quillian's Kernels. This is one of quite a large series of videotapes on Georgia civil practice and procedure. Today we're talking about dilemmas and depositions and otherwise proper or improper conduct during the course of the taking of deposition. And this is subsequent to the discussion last week or last month where we discussed a number of similar but yet less expansive rules. A reminder to everybody out there in the world, we are not giving legal advice. These are practice tips, things to be considered. Judges are not necessarily consistent, especially with respect to the topics we're going over with today. These are general guidelines, things to think about when you find yourself in a deposition setting, and a setting in which your conduct is quite literally controlled by yourself unless a judge is called to the phone to issue an order on the circumstances going forward. So, we talked a little bit about last time about off-the-record conferences with the witness. There's been some distinction made about whether a witness, let's say you're the lawyer representing the witness, and whether the witness asks you if he can ask you a question as his attorney versus you taking the witness by the hand and saying, let's go talk about this topic during the middle of the deposition. And there has much been written about that, about whether the witness's right to counsel is eliminated if the witness can't talk to his lawyer during the course of the deposition. And then there's much written about whether a lawyer is somehow obstructing justice or trying to influence the testimony, bring about some false version of the facts by taking the witness by the hand and saying, let's go outside and talk about this before you give your deposition testimony. And there have been cases certainly to come down on the side of once a witness is prepared and in the deposition setting, that witness is not supposed to be talked with about anything to do with the testimony that's being given. As a general rule in these settings, we all know we can pipe up and ask questions. We've talked about this particular subject matter, and I think that this time around I will not identify the people on the record who are asking questions so that people can free to be talk more frankly about what they feel about various circumstances. Okay, so you've got a circumstance where your client's being deposed, and what would be one of the things you would definitely want to do before your client steps into the deposition room with that client?
Review key documents? Is that what you're getting at?
Yeah, you would want to help prepare the witness, to help the witness be focused on the subject matter of the litigation, whether it be a document-intensive litigation or not. You would hopefully want to get all the documents that you think the other side might have that might impact your client's testimony so that you'll have them to go over to review with your client. And you would otherwise want to prepare your client as to what in connection with the deposition.
What questions they might be asked?
Yes, what questions they might be asked, the general rules and procedures, what they might expect of the opposing counsel, just name, rank, and serial number, housekeeping things like if you have to go to the restroom, you can tell the opposing party you need to go to the restroom and ask for a break at an appropriate time. But as a, yes, Mr. Blank.
The first thing you need to do is make sure that you and the individual sitting there are in agreement as to whether he or she is your client.
Okay.
Because it gets a little gray when you are talking to an employee of a corporate defendant and you need to establish whether you are or are not representing that individual, at least for purposes of the deposition, because that's going to dictate the whole way in which you prepare the witness.
Yes, and what comes out of your mouth in the very first instance with that witness, because you certainly don't want, if you're not representing the witness, you don't want to share your corporate clients all their dirty laundry for instance, in preparation of the witness. And then let me ask you this, if you're representing an employee of a corporation, and you share the corporation's information with the employee, are you not just representing the employee for the limited purpose of that deposition, or are you taking on the representation of the employee for everything?
Well, my practice in that situation is to have a very short form engagement letter that the individual signs acknowledging what the rules of the road are with respect to the representation, to at least try to avoid that problem. You know, but it's terribly embarrassing and frustrating when the first question the individual is asked at the deposition is, that person sitting next to you, is he or she your counsel?
Right.
And the witness says, I don't know.
Yeah, that does happen all the time. I agree with you. And we did talk about last time the situation where there's a stream of witnesses and the lawyer on the opposing side comes in and says, I'm representing Mr. X for this deposition, I'm representing Mrs. Y, I'm representing Mr. Z, for every single witness in a car wreck, for instance. Somehow claims representation of the witness who are not his clients, except for possibly that deposition at every single, we addressed that fairly thoroughly last time, but it is important to know whether the person next to you is a client or not. And if they are a client, does that somehow cause the company, let's say you're representing, to be stuck by their testimony in any way other than if they're not represented by you? I see some head shakes. You think the witness's testimony is just taken as the witness's testimony no matter what, regardless of whether it's a common lawyer?
Unless they're a 30B6 designee. The jury may perceive it differently. You know, that if the same lawyer represented the individual and the witness, the jury may construe the witness's testimony as binding on the client. But I don't think as a matter of law, the fact that the witness is represented by the attorney imputes that testimony to the client, to the corporate client.
Now, what about this? And this is pure matter of debate. Will the judge, if the witness says, oh yes, I met with Mr. X, we reviewed all the documents, we talked about what the testimony was going to be, as far as subject matters, etc., will the judge somehow conceive in their mind that that witness's testimony is more strongly imputable to the corporate client than they would if the witness said, I don't have an attorney, I'm here alone? Possible. Same thing with the jury. I mean, excuse me, the jury might think so as well. So you got to figure out whether the person is a client, and if they are a client, you have a duty to prepare them well, right? Because one of your professional responsibilities is to be thorough in your representation. And that means planning in advance. If you're the one in possession of all the documents and the witness hasn't seen them for 3 years, pulling the documents that are likely to be presented and making sure the person is aware of them. With respect to documents, does a witness have the opportunity to review a document before giving testimony regarding that document?
Yes.
No.
We've got a debate going. We're talking about Georgia civil practice, right? One person says the witness has the opportunity to review the document before giving testimony on it. Another person says
Well,
witness
I guess
does
it
not have
depends.
the
I mean,
right.
I've seen sometimes where they will ask a question about a document and say, I'm just asking you the question, I'm not going to show you the document yet. But if they hand them the document as an exhibit, they have a right to review it.
I agree with that. But the question is, can you test the witness's knowledge and memory without showing the document? And you have that right. And you know, when you prepare the witness, obviously, what you've told the witness is, if you're asked a question and you know there's a document that speaks to it, ask to see the document. If they refuse to show you the document, give the standard disclaimer. I could really testify more accurately if you gave me an opportunity to review the document, but if you insist on not doing so, here's the best I recollect.
Okay. Does anybody know how the rule of Queen Caroline's case impacts on this?
It doesn't apply.
It depends.
It doesn't apply because we're, what,
Well, I know it doesn't apply in federal court, I honestly don't know if it applies in state court.
The rule in Queen Caroline's case apparently was an 1820 law in England, which required examining attorneys to give the documents in advance of testimony to a witness for review. Apparently it was abolished sometime later in the 19th century because of the slowdown in the courts that it caused and the obstructive behavior that was associated with it. But apparently some courts still like that law. So, and I imagine it's different from judge to judge, even within the same court. So one thing I wanted to bring up about this topic of depositions is I truly believe it's whatever the judge thinks, probably after the fact, was the right thing to do, that is what was the right thing to do, even though you might not know what that judge was going to think before you did it to find out what the judge thinks. So, with respect to review of documents at the deposition, if you show up with your client and the other side has a pile of documents, do you have the right to say, are those the documents they're going to be using in this deposition? If the opposing lawyer says yes, can you say, well, let me see all the documents and we'll go review them with my client? I see some shakes.
No way.
I see a no way. Generally what?
No.
Generally no.
That's work
Absolutely
product.
no.
That's
Not
work
generally,
product and the
absolutely
nature
no.
of the attorney's opinion.
Well, Mickey, excuse me, other Mr. X. What about Ethicon Endosurgery versus United States Surgical?
It's wrong.
160 FRD.
It's aberrational, off the reservation and all.
This is, I will give this site a little more clearly, but it's 160 Federal Rules Decisions 98, Southern District of Ohio, 1995.
That judge was clearly a plaintiff's lawyer.
Because this, I believe it was in this case where the judge suggested that people not only could get documents in advance to review prior to the deposition, but also they could consider taking a break, including possibly overnight, to review them before the deposition commenced, which is definitely on the far right-hand side of Queen Caroline's case.
I can't believe that judge ever prepared to take a deposition, because the lawyer who's getting ready to take a deposition doesn't have the darn documents ready until 2 hours before this. If you're lucky. So. How are you going to give it the other side?
Okay, so let's assume that's on the far side of the right of a witness to review documents. Now, one kink I could see in that is if the documents had been requested by the party whose witness is about to give a deposition, and the other side admits, yeah, these are documents we have not yet produced, but we should have produced. I think if I was the defending attorney, I'd make a pretty good argument, well, you have to give us the opportunity to review them then, because we should have had these months ago. I could have prepared the witness. I would want to do that before the witness goes under oath for the deposition. If, however, these are documents never been asked for, and the opposing lawyer says, well, you never asked for them, I'm going to ask my questions, and I think in most cases you're pretty much stuck. The witness has to answer questions that are asked, and if documents are presented, then it's at that time that you can then see whether you can get a chance to look at the document. So let's assume you don't get to see the documents. The lawyer starts asking questions, and he's looking at the documents. I think this is Mr. J was referring to this circumstance, and the lawyer keeps reading documents, not into the record, but rather reading them and asking questions clearly or apparently off the page. Does the witness have a right to see that document? And I think Mr. M had the thought that you could say, the witness, could make a point. If I can only see the document, I might be able to talk about it more thoroughly.
Well, if the lawyer's representing on the record that this document says this and purports to read it, I think you have the right to look at the document to confirm that his reading of the document is accurate.
Who has the right?
The deponent and the deponent's lawyer.
In one of the cases in the handout, which I sent around, which for y'all out there in the world is Arthur J. Hall versus Clifton Precision. It's a trial court decision out of Pennsylvania, United States District Court for the Eastern District of Pennsylvania, 1993 U.S. District Lexus 10782. There's a suggestion that under the rules, the lawyer has the right to see the document to confirm that the witness in fact said what the opposing lawyer said the witness said that's in the document. Not necessarily the witness themselves have the right to see the document. What do y'all think about that distinction? That the lawyer for the witness can look to confirm that it's not a fake document that the questioning attorney is referring to, but rather, for instance, an actual letter written and signed by the witness.
That makes sense to me, because there could be other things on the document that you want to examine the witness about, and to show the document to verify a sentence should not allow the witness to be able to review the entire document before you can ask your questions.
Mm-hmm.
So I think, to me, that is a reasonable compromise, that the lawyer can confirm you're not misquoting, but you don't have to show the entire document to the witness.
Okay, and if the lawyer defending the witness did get the document, would they have the opportunity to take a break and go talk to the witness about the document?
If there wasn't a question pending.
Well, that's actually a big topic for today. Can a lawyer defending a witness talk to the witness anytime during the course of a deposition about anything relating to the subject matter of the testimony, as opposed to, do you want ham and cheese sandwich or a turkey sandwich?
I think the answer is yes. If the general practice that I've always been taught and followed was that if there's not a question pending, then a break can be taken and some reasonable discussion of the subject matter can be done. There are probably some lines that shouldn't be crossed on that, but that it's not against the rules to say anything about the case.
I disagree. I think a deposition is no different than on trial. And you couldn't ask your witness to come off the stand at trial and say, wait a minute, I'd like to go discuss that question with my witness.
Yeah, but how about maybe if you're in a trial?
Privilege aside, if you have an issue about whether you're getting into a privileged area, at any time you can discuss that with your client. But otherwise, my view, and I will concede that my view is contrary to what happens every single day in 99.9% of depositions, and it's a practice, and it's the rule do. You're going to do it until a judge tells you to stop. You're going to consult with your witness, you're going to coach your witness, and all that kind of stuff. But to me, the letter and the spirit of the rule is you treat a deposition exactly the same as trial testimony. Exactly the same.
I think what happens is both sides want to be able to talk to their witnesses, so neither one presses it with the other side, because then they're opening themselves up to having all their discussions with their witnesses.
So maybe
Yeah, but
if you had a lunch break during trial, are you saying that you couldn't talk to your witness about what would happen the rest of the trial?
There's a substantial line of cases that says exactly that testimony is continuous. And the fact that there is a break is fortuitous. It does not give you the opportunity, because it obviously encourages gamesmanship. That you try and adjust the trial day so you can resurrect your witness by counseling your witness. And I personally believe that that's the way it ought to be, but now you're running into the right to the assistance of counsel.
Exactly.
And, I don't know where that line crosses. To me, a lunch break, you shouldn't be able to discuss it with your witness. I could be persuaded overnight you can discuss it with your witness, but in a deposition, I just don't think it's proper, to run out of the deposition and do some more preparation.
Well, we're a self-regulating body, us attorneys, and we should have an overarching duty of professionalism which prevents any sort of gamesmanship in a deposition. Do y'all agree with that?
It's aspirational.
I hear silence. Mickey is certainly taking the position, Mr. M is definitely taking the position that the more professional route, especially under the federal rules, is to treat a deposition exactly as trial testimony, where there is no opportunity for interjection of the opponent's lawyer into the development of the testimony, except under the specific circumstance of determining whether a privilege will apply to the response to a given question. And if so, what facts support the existence of a privilege?
It just occurred, maybe there's some middle ground here. I appreciate what Mickey's saying, or what Mr. M was saying, but what I find happens so often is, you have this, say your client is a company, and you've got an employee who's testifying, who is at some level in the company. And I've seen this happen with all different kinds of people. You have what you think is a great prep session, you give them the usual things, you say, look, keep your answers short, don't speculate. If they ask you about a document, read the document. And then they totally blow it when you go to the deposition. It's like you never had the prep session, So as soon as you have a bathroom break, you just want to grab them by the collar and say, remember what I told you, And none of that would be privilege. I mean, none of that, I wouldn't care if the other side heard that. Just say, remember what I told you. Keep it short, don't speculate, da-da-da-da.
Tell the truth.
Yeah.
Nobody's gonna say, okay, I'm not a trial lawyer, nobody's gonna say you can't do that, not even Mickey, right? What,
No, that's
that's,
non-substantive.
yeah, right, that's that's just, yeah,
And that happens, I mean, you need to do that. I think every
mean, that's
deposition I've
another-
had to do that.
surely you can do that.
What has happened with me sometimes is you'll have a witness, if I'm deposing somebody, he goes to lunch, he comes back, and after lunch says, I want to state for the record that I need to change some of my testimony,
Yeah,
because
right.
I remembered over lunch, and that's where I make sure, you did this after consulting with your lawyer, you had a break, you talked to your lawyer, et cetera. Now, often the lawyer objects, but you gotta get it on the record that this change of testimony came after a break, during a break, while consulting
Well,
with his lawyer.
Do you ask that
What did you
witness?
discuss?
Hmm?
Don't you go ahead and ask,
Yeah.
what did you discuss with your lawyer?
Yes.
And of course, they'll object,
They'll
and
object,
nobody
they'll
goes
refuse
to
to
court.
answer, and then the question is it something you want to go to mad about?
And if you did go to the court, in this case, a superior court or a state court in Georgia, do you think you'll win asking the judge to compel the testimony of the witness regarding what the lawyer told the witness?
It depends.
Okay, it depends on what?
The judge.
Depends on the judge, yes. I mean, on the far side of, what Mr. M was talking about, is connection with the professionalism within a deposition. I've actually had a judge state from the bench that when he was in private practice, it worked really well for the lawyers to agree to do a fist fight over whether the question had to be answered or not. And then since he was a big guy, he thought it was very effective. And so, truly we're dealing with people here, and if you're talking about one question in a deposition where the witness comes in and says, I'm changing my story after lunch, cost-benefit analysis of taking something all the way up to an appeal over that one question, unless it's really a zinger, becomes very problematic. And you also, at least possibly, have the eventual trial where circumstances will be different. Okay, let's say...
Well, let me ask you, Henry, or Mr. H, well, you identified yourself. What has been your experience at trial, whether courts impose any restrictions at all on your ability to prepare the witness overnight? A witness who's in the middle of examination or cross-examination, the extent to which you can continue to work with that witness during an examination.
I think that many judges forget to mention it, but if any judge does mention it, they will say, the witness is to return to the stand tomorrow morning, no intervening discussions are to take place regarding the subject matter of the testimony.
And if that's the
Sure.
rule in trial, if you ask the court, why shouldn't that be the rule in a deposition?
Well, I can tell you one thing. What have y'all heard 1,000 times? this is a discovery deposition. In other words, lots of times the person who is asking the question tries to draw the distinction and say it's discovery, it's not for trial. So then you got the question of what if the witness dies in the interim, then it all of a sudden becomes a trial deposition. And you've got the depositions we talked about, which are perpetuation of evidence depositions, which could end up being a trial deposition at any time. So I would say that the legal theorists definitely believe that there's not supposed to be intervention in the deposition process for lawyers to impact the testimony of the witnesses. But as we know that somewhere along the line, as Mr. P was saying, and Mr. P, that you got to at least get the witness so they're on the right page as far as giving reasonably manageable answers, not talking about everything that happened during the weekend. And on the flip side, not influencing their testimony. And if you do, there's the threat of the witness being cross-examined by the opposing attorney about everything you said to the witness. Even if they didn't change their testimony, even if they've never given it before, if there's a break during the course of the deposition, I would say there's a reasonable chance that a judge would make the witness answer what was talked about between the lawyer and the witness during the break.
I have a question. If you have a scenario like Mr. J described, where someone comes back from lunch and they've clearly remembered all sorts of new facts or whatnot, and you were asking opposing counsel what they discussed over lunch, and that attorney says, yeah, that's privileged, what would be the best possible authority to cite at that moment to try to convince the attorney otherwise before going to the judge?
Well, I carry this case, which, as y'all can see, it was printed out from LexisNexis many, many years ago, when they had dot matrix printers. And it's the one I cited earlier from the Southern District of
Ohio?
Pennsylvania. I think it's the Pennsylvania one. Well, you know, the laws are the laws. I mean, this basically construes the Federal Rules of Civil Procedure. We've talked about how Georgia courts have said the Federal Rules of Civil Procedure are persuasive. There may or may not be a Georgia case precisely on the point. Probably ought to research that and find out. But this guy goes through a long litany of analysis as to why various things should play out and why they shouldn't, and he takes the position that basically there's no privilege between a lawyer and a witness during the course of a deposition except for to determine whether there's a privilege or not. And he also says that if there is determined to be a privilege, then the lawyer ought to have to come back in and state, we had a conversation, all we talked about was privilege, and we're not going to answer the question. But he expressly says there has to be a record by the lawyer stating that he had a conference with his client about the subject matter of the deposition. So, we can shepherdize this and see what we come up with anything from the Georgia courts. Okay, let's say the witness is handed a document. The witness says, I hadn't seen this document in a long time. I want to read it before I give you more answers. How long do you have to give the witness to read the document?
A reasonable time.
Reasonable. Depends on the length of the document.
Okay, what is
It
reasonable?
depends on your question. I mean, if it's a 50-page document and you're asking a question about one sentence, and you explain to the witness, I'm going to ask you one question about this one sentence, and the witness says, I want to read the entire 50-page document, that's a very different situation.
Mm-hmm.
So I think it has to be in the context of what you're going to ask. But you can't make the witness hurry up. You know, all you can do is if the witness takes an hour to read the document, you say, I'm going to tack that onto my time, which is irrelevant in state court because you got forever anyway.
Well, sometimes you do, sometimes you don't. We had a case last year where we had 25 plaintiffs and 15 defendants, and the judge ordered Each witness, including the core witnesses in this huge construction project, only had to be deposed for 6 hours each by all parties. And that she would consider additional time. I think she ended up giving a day and a half for all 37 parties to depose the witness. So you never know. But on the one end, there's the reasonable time, and on the other end, there's the possibility of the opposing lawyer making a motion claiming that the witness is being harassed or oppressed by the deposing lawyer. So I suppose you have to give the witness long enough to say that they've read the document for the purposes that you're asking about the document. If all you're asking is that your signature on this document, then they don't need an entire week to read it. What if the witness says, well, I want to read everything in this document before I answer any questions? My thought is you would have to just say, well, I'm only going to ask you about one paragraph, or do something on the record to make your actions seem reasonable to a court down the road.
I think it's fair for the witness to want to do a quick review of the entire document to refresh their recollection about the general contents of the document, and that what they've have in front of them is the entire document, it's real. But, you know, the full reading of every word, no, not if the question doesn't call for it.
Okay. If we were to just put on a scale what we're trying to do here, let's assume there's no videotape playing. At the end of the day, other than just being generally professional, if you're the deposing lawyer, what are you trying to make the record appear to reflect?
If you're the lawyer taking the
If you're the
deposition,
lawyer taking the deposition,
then you're reasonable, the other side's being unreasonable and
That's-
evasive.
that's right. And so, you know, if you tell the witness, I've given you the document, but you can't read it, is that, you know, doesn't this line say this, or didn't you admit this by writing that, then I think the witness has at least the right to go up and read the beginning of the paragraph to see if it says notwithstanding everything else in the document or something like that. Okay. Can you raise the objection? Let's say you're defending your client witness. I object, I don't understand the question.
That's not quite the right way to phrase it, but the same content and purpose can be done. The proper objection would be objection, vague, ambiguous, and then perhaps to turn to the witness and say, do you understand the question?
Well, some judges would take the position that by saying vague and ambiguous, you're leading the witness on to say, oh yes, it's vague and ambiguous. And they would say, those judges would say, the witness has the opportunity to make the determination whether they understand the question. If they do, they're answer it, so that all the defending lawyer should say is object to the form. Doesn't make any difference in the world if the defending lawyer doesn't understand the question. Because that lawyer's not the witness one way or the other.
The lawyer
I
has
think
it.
technically that's all you should say is objection to form. And then if the lawyer who's asking the question wants to truly cure the form, then he or she can say, you know, what is your objection?
Right. In which case there would be a burden on the lawyer objecting to the form to
at least say
give
ambiguous
information necessary to obviate a problem down the road.
Right, to allow the opportunity to cure. I mean, there's a spectrum here. Objection to the form is the most pristine. Objection, vague and ambiguous, you know, we're pushing it. But what most lawyers will do is they don't even stop there. They'll say, objection, vague and ambiguous, you haven't clarified, you know, what year you're talking about. And they'll basically give a coaching explanation to their witness as to what is vague and ambiguous about the question.
And they will also say, if they don't like the witness testifying about it at all, they'll say calls for speculation. It should not be answered.
But it happens all the time in state court litigation, and no one gets in
In federal
trouble.
court, nobody gets in trouble for it.
And I've had a few lawyers on the other side make a big deal out of it in federal court, cases in federal court. But, and I think in federal case, I don't know what y'all's experience is, it seems like speaking objections are much rarer.
Because a lot of federal courts actually have rules, local rules that speak to that issue.
Right.
And I've never seen a local rule in state court that gets into that.
The thing I've seen in state courts a lot more recently, I mean, last couple of years is virtually every case starts off with a case management order these days that says, if there are any problems with discovery, call me immediately.
Right.
And so that would be the way that some of these things could be resolved if too much activity went on during a deposition that was disagreeable. Well, this judge, keep this word in mind, surely you'll remember it, says all objections should be stated pithily
That'll work.
with the least amount of substantive comment possible other than object to the form or a directive not to answer because it's a privilege. Those are basically the two positions that this court thinks that you could take, except for if you get to the point of saying, I'm going to make a motion, we're going to terminate the deposition, I'm making a motion for a protective order. And one other exception, if the court has already issued an order saying discovery will only be on these topics and or it's limited to this amount of time and the person is violating the court order by either expanding the topics of discussion or they're running over their allotted amount of time or whatever the case may be.
I think another one would have to be lack of foundation, because that's a curable defect. That unless you've stipulated that all objections save as the form of the question are reserved, you'd have to assert your lack of foundation objection to give an opportunity to cure.
Now, why would if the opposing lawyer fails to lay a foundation for the testimony they're giving, wouldn't you want to sit tight and then move to exclude the answer at trial? If they rely on
You're
that
obligated to assert the objection to give the opportunity to cure unless you have stipulated that only objections as to the form have to be asserted.
Okay, I'll ask for a raising of hands, and then I'll repeat what I see. What percentage of depositions do the lawyers stipulate that they'll only object to the form of the question and the responses to the answer to the question? Let's say more than 50%?
Yeah.
More than 75%? I think that's
If I'm taking the deposition, I don't do that, because I don't want to be put into that situation
Right.
where there was another objection that I could have cured and the objection was not made.
right.
If I'm defending the deposition, that's the stipulation I always want.
Yeah, I call it a stipulation to be lazy.
Exactly.
But
So maybe, you routinely take depositions so you don't enter into that stipulation?
Yes.
And
And I refuse to enter that stipulation, and I'll say that we're governed by the federal rules.
and I actually do the same thing, and everybody goes, well, what are the rules?
If I stipulate, we're bound by the federal rules. I mean, the only way that you can get out from under the federal rules is by stipulation. And so I'm not willing, when I'm taking the deposition, to limit objections to the form of the question.
Has anybody ever had anyone do what Mickey does?
Yeah, I do. that.
Absolutely.
Have you?
Yeah. Oh, I don't do it in a disagreeable manner. If they propose that stipulation, I'll generally
Right.
say, that's just what the rules say anyway, the rules apply.
That's not what the rules say.
So I may be wrong. Let's see.
When in doubt,
Because that does
I've
not
never had
open,
anybody do
that does not open the door to objections based on relevancy and all that kind of crap, because that's not curable.
I've never had anybody take the position that, now, if you're the one taking the deposition and you want the other side to object for lack of foundation so that you can cure your line of questioning, that's one thing. But if somebody does not, if I'm defending a deposition and somebody is not laying the foundation for testimony,
You should-
I'm not gonna object.
Right.
And I don't think any court is ever gonna hold it against me for not objecting. So I'll just let the guy get the testimony and then I'll object at trial to the admission of that testimony.
And there
Because
was
there's no foundation.
stipulation?
Excuse me?
And there was no stipulation?
Yes, because I don't think that's the type of question I don't think a defending lawyer has any obligation to try to coach the taking lawyer into laying an evidential foundation.
That's the whole purpose of the objection. McElhenney has an article on exactly this issue, I'm sure.
Okay, well, we'll look at this. We just came up with another topic
To be
for Quillian's
continued.
current. Okay, what if the witness says, I don't understand the question? Does the witness have to answer it?
Shouldn't answer it.
The witness can say, I don't understand the question. And if the witness doesn't answer it, you know, the taking lawyer can go to the court and say, I want you to hold court that this witness has to answer this question. If it's a question, I suppose the judge cannot imagine that the witness wouldn't understand, given their competency, then I think the judge might force them to answer the question. In fact, they do that in trial, of course. But the lawyer can't object saying, I don't understand. They can, they do all the time, but they shouldn't object saying, I don't understand the question, therefore the witness doesn't. We talked about that earlier. Now, is there any burden on the taking attorney, the person deposing the witness, to tell the witness in the preliminary stages of the deposition that if you don't understand the question, tell me and I'll restate it and try to make it more clear?
No.
See, I heard one no, I see one head shake.
But why wouldn't you want to do that?
Well,
You would, but his question was, do you have to?
No, I know, but why?
yeah,
Why the
but
question being asked? I mean,
my understanding is I did that so that the witness could not come back later and say, well, like on cross-examination at trial, and say, I had no idea what you were talking about when you asked that question. Because it may be a bad way of the witness trying to weasel out their testimony, but nevertheless, it's a way that they try to weasel out their testimony. And if you tell them in advance, well, if you don't understand it, I'll restate it, that lessens that excuse at trial. The court in this case says no, because the witness can't be in any way coached by the lawyer to clarify things, they should be coached by the opposing lawyer to point out if they don't understand the question, which I thought was rather bizarre. I wasn't really aware that there was any obligation on the deposing lawyer to coach the witness
Well,
as to how to go about giving a deposition.
The court apparently said should be, not must be.
Right, the court recommended that be given, and in fact, he relied on the fact that the deposing lawyer had given that instruction as a basis for finding that the opposing lawyer had acted improperly by interjecting and trying to do talking objections and such. Okay. What sort of circumstances would result in you terminating a deposition?
Harassing a witness, possibly getting into asking questions of highly private and sensitive areas that they weren't entitled to get into, insisting on an answer to privileged information.
Okay, yeah, something that causes embarrassment, annoyment, other than annoying because the testimony has to be given that's not favorable. Something that's somehow or another, and it's hard to lay a record on this sometimes, that the lawyer who's asking the question is in fact being extremely intimidating to the witness. There was one time, it wasn't a deposition, it was an arbitration, but the witness that I was cross-examining, who was a lineman from the University of Oklahoma, had a ring about this big around, started saying, are you calling my veracity into question? And he started to come across the table, stuff like that. And I just said, well, it's up to the arbitrator to determine that. But that could be a circumstance where it was in a deposition. It would be, in that case, the witness perhaps abusing the lawyer, but that might be a reason for the lawyer to say, we're gonna suspend the deposition, allow things to get cooled down, but in that instance, you would want to put on the record exactly why you're suspending the deposition. Now,
If you're taking the deposition, you can terminate it if you insist, if the other lawyer keeps giving these long speaking objections and you keep insisting they stop and they don't, then you could terminate it and say, we're gonna go to the court.
right, and would you want to terminate the deposition, or would you want to suspend it in that instance?
I'm sorry, suspend it.
Okay, so what you would say on the record is, I'm suspending this, opposing lawyer is acting completely improperly. We're gonna make a motion before the court, and perhaps take the remainder of the deposition at the courthouse, keep this under control. Sometimes that'll, of course, cause the opposing lawyer to shut up immediately, and let you take your deposition entirely without any objections. But obviously, you need to be careful not to get bamboozled into, as if you're the defending lawyer, into doing nothing just because the taking lawyer is making all sorts of threats. That's why it's important to know what the rules are, know what you properly must do, know what you properly can do. For instance, you don't want to waive privileges just because the taking lawyer gets mad at you every time you try to assert a privilege. Now, if the lawyer, if the lawyer on the other side is taking the deposition and you're defending, asks a really, really ambiguous question that you can tell the witness is just about to answer, as the defending attorney, can you pipe up and say, I instruct the witness not to answer? Okay, yes, you literally can do that. And it does in fact happen, doesn't it? The position would be that that is directly interfering with the communications back and forth between the asking lawyer and the witness, and at least some courts would object, would say that's improper and possibly sanction you for telling a witness who's merely had a question asked to them, and who, in this instance, has been instructed to ask the questioning attorney, tell me if you don't understand the question. The court would potentially find that that was improper conduct to instruct the witness not to answer, because the reasons for instructing a witness not to answer would only be, I'm going to assert a privilege, you're outside the bounds of the court-ordered limits of discovery, or I'm going to make a motion for protective order.
And you could take the position that that question is so abusive in its ambiguity, so unfair, that you're going to move for protective order against it. Because, the trade-off here is, well, Mickey's saying that it's supposed to proceed just like at trial. Well, just like at trial, there would be a judge there to rule on that question then and there. And so if you don't have that protection, then you're going to have to carefully and cautiously observe, sometimes say, let's wait and see what the judge has to say about that question before the witness answers.
Well, you also have a client to answer to, and you may have to take one for the team and just risk even sanctions to avoid losing the case by allowing your witness to kill you with the testimony. Because when that deposition's over and your client is just totally hacked at you because you didn't protect him or her,
Right.
you may have done ethically everything you should have done, but you've lost your client.
And Mickey, when I think back to the way this was built for corporate attorneys to attend, that's the first mention I've heard of a client. So other than maybe the clients that are being deposed. So why don't you tie this in for us?
All right, well, every client, what do they expect from their lawyers?
Zealousness, winning.
They expect you to win, and they expect everything the judges don't expect from you. In many ways, they respect Rambo litigation, theatrics, accept help. I'm sure they expect help. Don't let me, by testifying, step into a trap so that my case isn't as good as it would have been.
But unless the client is being deposed, the client won't be there. guess
Awful
it could be,
is the
but they
client,
won't.
though.
Right. Yeah, they would blame you for some other employee of their company giving bad testimony. But that's one reason why we're talking about this, because the sanctions could be anywhere from, let's say you wrongfully, the court finds, told a witness not to answer the question because the question asked called for speculation. The range of sanctions could be, well, I'm going to charge you, Mr. Objecting Attorney, with the cost of the motion and the cost of starting the deposition. Let's say it's out of town or something. That could be one side of the sanctions. In another case where the lawyer was substantially more abusive than that, the court expressly said that the defending attorney ought to be disbarred. Castillo versus St. Paul Fire and Marine, 828 Federal Sup 594, Central District of Illinois, 1992. So, and that's one reason why I put on my little subject matter for Quillian's kernels, avoid extreme embarrassment. You definitely don't, even if you thought you were doing a good job for your client, you definitely don't want to have an order issued against you saying you ought to be disbarred because you did it. So that would be on the extreme side of probably a very conservative judge and a very aggressive attorney. But
Quick question. What if your client refuses to answer the question? Like, this is kind of a client management question, but something's been posed, you think it's probably a fair question. You've got a client sitting there that goes, nope, I'm not going there. What do you do?
Take a break. I've had that happen.
well,
Yeah, I've had that
you've got
happen.
several options
Well,
now that
yes.
we've talked about this. You can say, I have read this case from Pennsylvania and I can't talk to you, client. So you got to make up your own mind, and if you get hit with the sanctions, you get hit with the sanctions. You can't even say that, supposedly. Or you could say, if it's directly on the subject matter, are you damaged, personal injury plaintiff? Did you suffer damages? If the client says, I refuse to answer that question, then you obviously want to tell them, if you're the plaintiff's lawyer, answer it. But, and I think for the most
There's a
part,
difference between counseling a witness
Right.
to try and limit testimony and encouraging the witness to testify as to proper subject matter.
yeah, I think it would be appropriate to say that to the witness, you need to answer the question. Now,
And to lay out the possible, consequences if you don't.
right. Now, hopefully, it's not a circumstance where you find out the client accidentally killed their child or something.
Forgot to tell you.
Yes. But that goes into preparation beforehand. You try to find out the things that are likely to come up that might be really problematic. And so that sort of goes into it. There's always the question of whether you should threaten terminating a deposition. And I see a lot of people try to pull that off on a fairly regular basis. If you do just a little bit of this or a little bit of that as far as objecting. For the most part, I think economics sort of drive whether you're going to get done with the deposition or not. If the very first objection you make, the other side who is thoroughly prepared for the deposition says, I'm going to terminate the deposition if you do anything more than object to the form, lots of times they're bluffing. I suppose occasionally they're not. But it's a risk you have to take, and you have to determine, look at your own actions, figure out whether you've been within the realm of reason or not.
Yeah. And I was involved in a state court case years ago where the attorney did, one attorney was giving what the other attorney asserted were speaking objections, and finally terminated the deposition. Went to the court, and the court issued an order saying, you may say nothing other than object to the form.
Mm-hmm.
And that was in a court, and that was state court, so it does happen.
I was in a court recently having taken a deposition with a very evasive witness who I believe ultimately got the testimony I needed from. And the court said, having read the deposition, I can't believe you didn't terminate the deposition and come before me and make the witness give the deposition at the courthouse. I've never had a judge say you should have done that.
Why didn't you bother me?
But I suppose it's all in the eyes of the beholder, and that's one of the things that we want to talk about in Quillian's kernels this go around. And I believe
Todd, were you in the slavery sanction in New York?
I was not,
You
I
remember?
was tangentially involved.
But that's an
Had
interesting
nothing to do
thing.
with sanctions.
Well, what does the judge do? He's gonna hold a hearing on whether to sanction? Does that happen first? I'm trying to remember what the context was, because we had to go and get other counsel for our client while we defended ourselves against the possibility of sanctions. As I was telling you earlier, the client, talking about clients sure didn't understand that one.
Mhm.
I mean, they were really mad. Personal friends of mine, they were really mad.
Well, the procedure would be, a person would have to make a motion, oral or written, depending on the rules. If they were, let's say they moved to terminate a deposition, they would have to make a motion as to why the deposition was terminated. Judge might accept that over the telephone, right there in the deposition room, or the judge might require written briefs and everything else.
Well, I've gotten judges on the phone before, in the middle of a deposition where witness was not appropriately answering, we thought, or opposing counsel was constantly making speaking objections. And in fact, and the judge got on the phone, we worked it out, we continued with the deposition. And I've also had a judge recently tell us if we have a problem in that regard, to get him on the phone. He invited us to call him.
If the judge didn't tell you that, would you reasonably expect to be able to reach him in the middle of a deposition?
No, I think then, your backup is to suspend, get a copy of the transcript, and, file a motion, and you've got the evidence in the transcript.
Yeah, I think Mr. S. may have been out. More recently, I've been getting more and more case management orders that say, call me before anything else. But the basic problem is that the judge is in a criminal trial all day, every day. It's just a nice thing to have on there, and I suppose they're thinking maybe that particular day you're taking the deposition, I'll be available to take the phone call, and I'll avoid having to read a lot of briefs. But I would say, on average, the probability of getting the judge on the phone is 25% or less at any random time when a deposition might be taken.
I would think so.
All right, well, I think that's it for Quillian's Kernels this month. Thank you for your
Good work.
participation.